Happy Friday, everybody. Welcome to another weekly privacy chat where we chat. We talk about the big issues of the day. Sometimes me just saying what's on my mind and hearing what you all think. But today I'm lucky to have with me an old friend. He's not so old, but we go back a long way. Alan Chapell. Alan and I crossed paths initially many moons ago at DoubleClick. So he sort of started out a bit in the ed tech world like I did and has gone on to be a leader in not only ed tech issues, but works with, represents both legal, consulting, policy type initiatives across a wide range of companies, has led efforts at the NAI, the Network Advertising Initiative, represents and does work for lots of ed tech companies, but lots of other strategic stuff. And maybe he'll drop some information about that. But he's here with me today because he's also been one of the leading go-tos at the U.S. Trustee's Office for this role, mysterious to even me. I've been around a long time and seen a lot of things, but remember the early creation of this ombudsman role when, in the wake of the ToySmart case, the uproar around what's going to happen to the kids' data, and the FTC stepping in, and Senator Pat Leahy drafting legislation that helped create this consumer privacy ombudsman. But frankly, just in the brief chat I had with Alan as we were, getting ready to go live, I learned stuff I did not know. And I'm now going to do a bunch of weekend reading, thanks to our friend Omer Cheney for posting a bunch of the recent law review articles and critiques. So, Alan, welcome. Any key bio information? The most important thing that I did leave out, go follow this guy on Spotify because he's actually an incredibly talented musician, and love it when we are not unidimensional people in our world, and they're people actually succeeding and doing really cool things with their music. And I think your musical career, you're known as Chapell, right? Like that.
I just go back to my last name, just like Bon Jovi.
All right, so Chapell, learn and listen to his really awesome, talented performances as well. What's the role? Any other key bio information besides?
No, I think you hit on it, Jules. And thank you so much for having me on. It's really fun to be on something that I regularly am a viewer. So a huge honor. Thank you.
Awesome. Delighted to have you. So what is this magical role? Do you get a badge? I still have my badge here from my days as consumer affairs commissioner. Occasionally I use it to scare people in the supermarket or something if they haven't labeled their prices right and all that. But what comes with this? What is the scope? When does it get appointed? It's not in all bankruptcy cases. It's in some. Do you have magical powers to block the sale? Give us a good intellectual download here.
Sure. I mean, the whole thing came about back in the .com era, where a company called ToySmart made a promise in their privacy policy that they will never, ever sell their customer data. And then I'm going to yada, but a year or two later, they were out of business and they were looking to sell their assets. Now, one of their assets was a customer list of, I think, 50,000 of their customers. And so they proceeded to sell their customer list. And then the FTC and a whole bunch of state AGs said, wait a minute, you promised you wouldn't sell your data. That promise is enforceable, and we are going to take steps to block this sale of data. Now, long story short, because ToySmart ended up, I think, selling the data to Disney, who summarily destroyed it. So it's not so much about ToySmart, but as a result of that controversy, they changed the bankruptcy code and they said, okay, you need to hire or engage a consumer privacy ombudsman if, and this is the really big part here, if your privacy policy made representations or restrictions on your ability to sell your customers' data. So what that implicitly means is if your privacy policy said, hey, we'll sell data to anybody under any terms, and that's just how we work, or if they said, more likely, well, in the event of a bankruptcy or merger, we will sell the customer list as part of the assets. Well, if either of those things were in the privacy policy, arguably, you don't even need to engage a consumer privacy ombudsman. We can get into 23andMe, but I wanted to start off with that. I mean, it's a very limited set of circumstances where one needs to engage a consumer privacy ombudsman. And it sort of made sense 20 years ago because, most judges were unfamiliar with the nuances in privacy law. Actually, still, I think most bankruptcy attorneys, other than Omer, are limited in terms of their knowledge of privacy. So my role was to come in and educate the court on what the implications are to any sale that involved personal data. And now, I think other people might come in here and tell you something different. I viewed my role as a true ombudsperson, where my role there was to represent the interests of consumers, but recognizing that, that it was also beneficial potentially for a sale to go through, because that's also an important asset. So what I would do is I'd work with the debtor. I'd work with the U.S. Trustee's office. You get an assessment of the data that is contemplated for transfer, whether it's email addresses or social security numbers or what have you. And then we would evaluate who the potential acquirers are of the data. And there was actually a 4-pronged analysis called a qualified buyer, that if the purchaser fell within the qualified buyer rules, then generally speaking, you were subject to a notice and opt-out choice regime. In other words, that the data could be transferred with just a notice to customers and the ability to opt out from having their data transferred. Now, and maybe we just go through the criteria really quickly. So a qualified buyer is an entity that concentrates in the same business and market as debtor, expressly agrees to be debtor's successor in interest as to the customer information, agrees to be responsible for any violation of the policy following the data purchase. And then number 4 is shall not disclose, sell, or transfer the customer personal data to any third party in a manner inconsistent with debtor's privacy policy. So if you meet those criteria, the path, at least with respect to U.S. personal data, is pretty easy. It's a notice and opt-out choice thing. And often that meant, some notice in debtor's store, a notice on debtor's privacy policy. If the debtor had an email list, some notice going out via email, and basically an opt-out choice regime. Slightly different for places like Europe, who had a more thorny set of privacy laws. But I'll also say more often than not, at least in my experience, I've done 25 of these, more often than not, the amount of EU data was a rounding error that was not worth transferring or even a lot of consideration. And so anyway, so I come in there, I talk to the debtor, I get a sense of what's being collected, I get a sense of whether the potential purchasers meet the definition of qualified buyer, and then I issue a recommendation to the court. Now, I will tell you, every single one of these, the court has accepted my recommendation, but I'll also say that I would float the recommendation to both the potential purchasers and the debtor, again, seeing my role as ombudsperson to find a solution that works. Occasionally, purchaser will come up with a couple of suggestions. Some I agree with, some I don't. There's a little bit of a negotiation in there, but that's really how the process works most of the time in my experience.
Yeah, a couple of quick thoughts. So clearly, if we had a general consumer privacy law, the world would be very different when it comes to these, because we could address what we expect the norm would be when it comes to transfers of data, transfers of sensitive data. But number 2, one point that I continually make to the California advocates who led us to CPPA and CPRA, it was the norm in corporate privacy policies before the California privacy law for policies to say, we do not sell your personal information. Most Fortune 500 or consumer brands felt that that was an important thing to say. And for people who worked at companies, that was the incredible, powerful thing that those of us who did legal compliance, when the business wanted to do this or that, do this, they said, well, that would be a sale of data because some third party would be getting benefit of the data in some personal way. Can't do it. Oh, yes, there's ad tech, but okay, fine. And okay, that needed to be dealt with. But as a result of the fact that ad tech was sort of the driver, many companies today say, because they feel they need to, because they've got some advertising exposure, we sell your personal information. Go opt out of sale if you don't want to. And of course, most users don't. So the express ability to sell data, whether companies do or not, beyond their ad tech exposure, well, that's a different story. But legally, they've positioned themselves in a way where perhaps they might not actually need to go through the sort of oversight or ombudsman process. So super interesting. I guess the second point is, we have this instinctive, like, a sale is bad because it'll be worse. I don't know if you have your data at 23andMe and you don't want it sitting around because of all the risks of genetic data sitting around, go delete it. But if you got it there because you like the ongoing updates and the new sorts of analysis that can be done, and the stuff keeps getting more and more accurate. Now you learn you've got heritage from some corner of the world that you didn't know you had that ends up being available, or because of other genetic analysis. Is it a bad thing if a qualified buyer keeps it all going, right? I mean, whether in bankruptcy or not. Now, I get that in bankruptcy, we are particularly worried that a company could do things. Another company worries about reputation, has resources. So we're worried that, you don't care. You sell it to some third-party data broker or somebody who's going to, use the data in some way that maybe is legal, but is a very different sort of consumer brand relationship. We have a question from Marlies McQuillan, who says, what do we make of an academic with limited practitioner experience taking on this role for such a high-profile bankruptcy? Well, Marlies, Richard is perhaps one of the most brilliant human beings I've ever met, a fierce privacy advocate in his legal scholarship, a practicing legal expert who does do private sector sophisticated work. I can't think of any. Now, we'll talk about whether he's going to have the tools. Alan might help us understand a little bit more about the 23andMe case, but I think commendable that someone like Neil, who's got a reputation as well on the line, isn't. Alan's got a great reputation. But Alan is not a privacy advocate who really is fiercely yelling at industry all the time. Sometimes he does yell at industry because he does these sort of mistakes. But his profile is different, as maybe perhaps some of the other consumer ombudsmen, of Neil, who people are going to be like, Neil, you're this fierce advocate. And by the way, Neil also is an expert on health data and helps run a health center. So
I would add,
go ahead.
He's also in the same area as the U.S. Trustee's Office where the bankruptcy is being held. And there's some value to that, because this is the exact type of scenario where he's probably going to you're going to want him in court a number of times. And so I have no issue with the appointment of Neil. I do not know him, a tremendous background, but this is a difficult, if not impossible task. So, because as I was thinking about this role, it's sort of combined privacy and security. And I don't know a lot of people who have both privacy and security chops, where like I feel super strong on the privacy front, but not necessarily on the security front. And then secondly, this is an entirely different thing than the 25 cases I've done. Look, I did St. Vincent's Hospital. That was similar. I did XY Magazine, which is not exactly the same, but but has some pretty stark considerations. But just think about biometric data and all of the genetic data that's in here. This is a huge task. And then on top of that, there seems to be some uncertainty regarding who the potential buyer is going to be. And then on top of that, I'm not sure that the 4 criteria for qualified buyer, which gets used in most of these over the years, I'm not sure that much matters. Because again, the problem here isn't the bankruptcy code. The problem is that we don't have a comprehensive privacy law in the States, and that it's a fair question. Like, if I happen to live in New York and we don't have, a lot of rules around biometric data, well, why are my rights different than somebody who lives in, say, Chicago, where they do have some rights around that? And that's the thing that I think a lot of the state AGs and the FTC are jumping up and down about. And I think that's right.
Look, I'll note, obviously, Regeneron has been noted as a leading buyer here, and there could be a lot worse outcomes. I mean, there's data brokers, there's people who might want to market. I don't know all the reasons why I might worry. There are some who might be more comfortable with their data in the hands of a large pharma company that wants the data for genetic research, as opposed to sort of, consumer data companies and so on and so forth. And a lot of, but not all, 23andMe folks have opted in to research use of their data by pharma companies. Now, I guess people might quibble how good there's a pretty decent flow there, frankly, of opt-in, and I'm sure Neil and others will look at it carefully, but there's room to argue that, this is perhaps a more qualified buyer in some ways than even the seller. But you were pointing out that in this case, because of 23andMe's policy, which said data can be transferred in case of bankruptcy, technically they're not obligated. This is really obligatory when the company has said, we don't sell data, and now you're in bankruptcy, and the trustee have sort of the ability to be blah, 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 blah. This goes away because there are other rights and stakeholders and people are going to lose money. And so even though you said X, sorry, you ain't going to get that. When companies disclose data is going to be transferred, this is not technically necessary. So they're sort of going above and beyond to try to be responsive to the concerns by putting Neil in place to make what will only be a recommendation to the trustee. But let me just tell you some other thing about Neil. A number of years ago, I was at an event where academics and civil society and others were being invited to sort of brainstorm around like IoT privacy and IoT privacy notices. And Neil was one of the participants. And I had the misfortune of being like the moderator of this session. And I had to get these experts to kind of go through, here's how you might design this thing. And Neil was not having it. Right. The rules were help us design a smart TV like IoT notice. And Neil was just challenging the entire premise that like people should even be in this position and so on and so forth. So I'll bet my druthers that a creative guy like this is not simply going to put on a very calm hat and say, well, here's the deal, but will creatively sort of challenge the strictures and the opportunities, because this is the kind of thing that animates Neil, right? Your worldview has got to be reoriented if you want actual consumer justice. Now, whether the trustee knows what they're in for is a different story.
I feel like everybody involved here is perhaps bitten off more than they can chew. This is not an easy gig. It's a high profile, it's a high prestige gig, but boy, it's difficult. Now, I believe Neil has a team of people helping him, and presumably they've got a whole bunch of additional skill sets. And the budget for this was significantly higher than anything that I've been involved with, and I think rightly so. But to your earlier point, Jules, my read of the bankruptcy code is you don't need a consumer privacy ombudsman. Now, that's separate from the question of whether it makes sense to engage one. And I think that's why the AGs and the FTC and a whole bunch of others have been jumping up and down. But it's not the bankruptcy code's fault, and it's not 23andMe's fault that they didn't initially engage one. It's that you're technically not required to do so. And then once you agree to do that, then, there's it kind of opens up its own little rat's nest of requirements. So I kind of understand it from 23andMe's standpoint.
So in some of the literature, there have been proposals for how to sort of improve this situation, both capturing more, because there are a fair number of cases where you may not need it, whether it's because you said you're going to sell data, or you said you're going to sell it in bankruptcy, or the data may or may not be exactly personal as sort of defined by the statute. Do you have thoughts? I mean, Senator John Cornyn dropped a bill this week amending the bankruptcy code and this consumer ombudsman section, but very specifically saying, well, when it comes to genetic data, there needs to be an express opt-in. And, my reaction was, that's kind of narrow. If there's a problem here, I mean, my search data, I'm not sure I want that being sold, or my precise location data, or my non-genetic, maybe very sensitive health data, or location data, or I don't know, kids data, right? Like, why are we using this opportunity? And yes, genetic is very sensitive and all that sort of thing, but well, if we're going to fix this, let's fix it. Should every personal information sale need a consumer privacy ombudsman? If you had your wish list of how to make this work better for consumers, and also recognize we don't want to destroy, I mean, there's M&A happening all the time. If I know that I can't sell it in bankruptcy, then I'm going to sell it as soon as there's some other economic stress. Like, what's the path to improve this?
So even before I get into that, I just want to make one observation. So in my experience, part of the story here is that bringing in a CPO is insurance against the deal blowing up. And the U.S. Trustee's Office, I think, is well aware of that. There's definitely been some cases where, like, it was questionable whether you really needed one, but it was helpful to take privacy off the table as something that could derail, particularly with large deals. And I'm sharing that in this context because regardless of what I want, I think the net is you're going to see more CPOs hired by U.S. Trustee's offices because they don't want the exact, circus that sort of erupted around the 23andMe sale. And so you're going to see more of these appointed, whether or not it even meets the statutory authority for an appointment. Now, if I was running things, I would create a sliding scale of sensitivity and scope of data collected and somewhere set a threshold that if it goes over, a 7 on the Chapell scale, that you need to engage a CPO. But I say that knowing that I want that in a comprehensive privacy law, because it's weird to me that we don't draw those distinctions around sensitivity of data and scope in many, many places as we're crafting, worldwide, privacy and data protection laws. So that to me is but I also think that's only part of the story too, Jules, because what you really need then is a fairly turnkey way of making assessments regarding how you were evaluating potential acquirers. Like, it's difficult having done 25 of these. It's challenging. You come in, sometimes you have less than a week before the sale hearing. You've got a lot of work to do. Now, you've got more time in 23andMe, but you also have an order of magnitude more complexity and more data that you need to consider. So I think what you need, in addition to just setting the bar somewhere of where you need to engage one, you need some type of criteria around what is a safe transfer of data and where are is it just limited to, well, they got a consent, and is it the scope of the consent, or is there something more because it's genetic data? And I'm not sure of that. I'd really want to think that through. But to me, that's almost as big a deal around that's as big a deal as talking about the why you need one or when you need a CPO. It's really about what are the clear criteria, because I don't think that the qualified buyer criteria that have been used for the last 20 something years alone is sufficient.
Yeah, for some of the folks in the comments who are really getting into some really deep questions, let me ask you this, and please do post if you can. What would your ideal outcome be in the 23andMe case, right? Because one outcome is, sorry, bankruptcy, destroy the data, almost on a human rights notion. I gave this very sensitive, high-risk data to you, 23andMe. I trusted you, and I don't care who buys it or what promises they make. You don't have the right to give my data to someone else. without me expressly agreeing. So that's, one human rights driven concept. We are, however, still in a world, at least in the US, where this is a data and rights and assets and consumer protection driven infrastructure until Congress imbues us with some human rights when it comes to privacy, perhaps. And so the courts clearly do care and should care about all the vendors who are going to lose money and all the participants or the people who maybe even want an ongoing, service. And it's quite fair to say, can we ensure that people are not put at different risk, right? If I put the human rights question aside of my relationship with who I gave data to say, look, you shouldn't be worse off. Maybe we want to even make sure you're as good off, right? Which is a very different framing, right? At that point, I want to care who's going to buy it, and are you going to give me the same protections or the same representations? All right, here's Omer. Omer, if you want to jump in live, we sent you the StreamYard link, but maybe you're sitting in your pajamas working remote as lawyers get to do today, or hiking. So what does Omer say? Omer Tanay, our longtime friend, senior fellow, and initially a bankruptcy. I did know he started out in bankruptcy, but that's only because I know him a long time. Omer Goodwin says, it sounds like, as ever, the problem is the lack of a U.S. privacy law. Well, I think we're all in vehement agreement on that. Those who would like to hear whether or not there will be a U.S. privacy law are invited to join the Future Privacy Forum on June 11th, where Congressman Dr. maybe knows something a little bit about genetic data, Congressman Dr. Joyce, the chair of the vice chair of the House Energy and Commerce, but the chair of the Privacy Working Group, where he and other Republicans are trying to get some consensus around what might be the path forward, will give the opening remarks on June 11th. Yes, you can still get some tickets at our website. Any data, says Omer, can and will be bought and sold. All you need to do is have language that says we may sell it in bankruptcy in the privacy policy, which we flagged. As Jules said, CPPA has led to everyone saying sell. And aside from the lack of reputational capital for the seller, is there at all anything special about the bankruptcy process, if anything, even without the ombudsman? So I guess, there is some argument that bankruptcy is a unique time to worry about crazy, wild, distressful things happening that might not be in the best interest of the consumer, right? Ideally, let's solve this for everybody. And if we could use this opportunity to do so, awesome. But I guess you do recognize, Alan, that there is a unique reason to protect people in bankruptcy in particular, right?
Well, there is. When a company is in distress, they are sometimes prone to making different decisions than when the company is healthy, and so you don't want somebody going out of business and effectively throwing consumer privacy interests completely under the bus. One thing that I think is kind of interesting, there's been a couple of things in the chat about 23andMe and their security vulnerabilities, and I can't speak to those. I read in the news what everybody else reads. But on some level, just to throw a grenade in there, those are irrelevant to this discussion. What's relevant is what are the security processes for the potential acquirer, and what is the security processes pursuant to transferring from the debtor to the acquirer. And so hopefully whoever does buy this has better or more robust, or describe it, security measures. But the fact that 23andMe arguably didn't, I'm not even sure is part of the equation here.
Yeah. Marlise says, well, what she'd like to see is that it be de-identified under HIPAA expert determination before it changes hands, and that the samples themselves, the raw data, be destroyed. More time should be given to object. Point, although de-identifying genetic data, particularly complicated. Again, I think we did an FPF paper a couple of years ago. I think this was jointly myself and Khalid El Imam around some of the challenges and paths forward for de-identifying genetic data. I've got to look back at that and see whether there's been progress in that area.
But also, by doing it that way, you are limiting the value of the data set to the potential acquirer. Now, like, the privacy side of my brain says, great, let's do nothing but protect privacy interests. But that's not the role of the ombudsman. The ombudsman is to represent privacy interests, but within the totality of the, hey, is there a way to extract some value for investors? So, privacy is an important consideration here, but it may not be the only one.
So this is not the consumer privacy advocate. This is the consumer privacy ombudsman advising the trustee about a broader range of issues than solely here's how to best protect consumers. It's how to best protect consumers and preserve utility in a way that is credible, given the need to maximize payments to vendors and so forth.
And there's no guarantee that the court is going to follow the opinion of the consumer privacy ombudsman. Now, in my case, it's always happened, but in part, that's because we come sort of united to the court saying, hey, here's the solution, here's why it makes sense, and here's why it's in accordance with applicable law. But if you come in there and say, no, I disagree with this, and everything should be opt-in consent, I query whether the judge is even going to listen to you.
Kylie Miller says specific notice to individuals and opt-out. Okay. I think that's already required. Is it not under the code, or is it?
Well, that's certainly how I've operated. If it's to a qualified buyer, leaving aside that this case has some special types of data, but generally speaking, if it's to a qualified buyer, then it's a notice and opt-out consent regime. Query whether I would have adopted something if I were, privacy ombudsman in this case, whether notice and opt-out choice alone would be sufficient. I don't know. I think I'd be very tempted. If you're just going to go notice and opt-out, boy, that notice needs to be really, really effective.
Or maybe all the people who, in theory, opted in, if there is good evidence that they've opted in, well, their data, which could be licensed to Regeneron today. In fact, 23andMe has some deals with pharma companies, or current. I think they've announced various de-identified deals, as Marley said. Brad Jansen, who I know appreciates the significance of people being able to leverage and learn and do genealogy and other stuff with their data, flags that if you are in that bucket, before you delete, you should download that data, because maybe you want to take it elsewhere. Obviously, if you're done, go ahead and delete, and that's been the advice from some of the attorneys general. But if you are someone who wants to participate in genealogy or in further research, you just don't want it to be in this particular situation, a good reminder to exercise your rights to download. It is increasingly challenging to upload that elsewhere, in large part, as I learned from Brad. There is this issue of investigators who upload data from a crime scene or a suspect to some of the genealogy databases to learn about their relatives. And then they go visit those relatives and try to find, well, did you have anybody who, was potentially involved in this crime? The companies do not want this to happen, do not like this to happen. And the Department of Justice has a policy, a preliminary policy that they put in place a number of years ago saying, don't do this, because it's almost like a dragnet search. But there's some information that, well, it does indeed happen because it's not law. So another thing Congress might want to do is give us some better protections against these wide sweeps or sort of misuses of this potential by law enforcement. On the other hand, they have caught some, I think the Golden Gate Killer, there was a California case. But again, does capturing, a bad actor warrant all of us being sort of suspects? Anyway, so much to dive in. Omer, thank you for the post. Those who want to read more, take a look at it. The rest of you should be relaxing with Alan's music over the weekend, because it's been a stressful week. All kinds of state privacy laws are continuing to move along. And please join us on June 11th if you're available. Alan, thank you for taking a couple of minutes out of your busy day to chat with us.
Thanks, Jules.
Always good to catch up with you. Hope to see you sometime soon. Happy Friday, everybody.
Take care.